Good morning, everyone, and welcome to the Remuneration and Proposed Company Amendment Bill webinar. Sure, that's a mouthful. I am Misty Keep. Due to IT reasons, you will pop me up as Ntokozo, but I'm Misty Keep. I'm an M&A partner in the Johannesburg office, and I'm going to be facilitating this webinar today, together with a number of my colleagues who I will introduce you to shortly. Before I do introduce the panel, I think it would be useful to run through a few housekeeping items that will hopefully enhance the webinar experience for everyone. As participants, you would have noticed already that you have been automatically muted and the chat functionality has been switched off. We don't want anyone getting out of hand. If you do have questions during the webinar, please feel free to use the Q&A tab that's at the bottom of your screen. Those questions will be sent to me as facilitator, and I will pick a few of those and raise them with the panel during the webinar or towards the end. Of course, if you have a question that doesn't get raised, either because I've missed it or we run out of time, please feel free to reach out to any of the panelists after this meeting. We'd be happy to speak to you offline. Do note we aren't going to be responding on the Q&A in writing. So either questions will be discussed or we can discuss them separately offline. And then if you haven't had enough of all of us after this session, you can watch it all again. It's going to be recorded and will be available later today on our website at www.bowmanslaw.com. Now let's get to the good stuff. Let me introduce the panel. First up, Martin, give us a wave, please. Martin Hopkins is the head of our Reward Advisory Services team. He works closely with our employment and benefits practice together with our tax practice. Side note, he is a mathematician and computer scientist, so smarter than any of the rest of us on the panel. He regularly advises top South African and international companies together with their boards on a full range of compensation matters, and is basically our expert in all things remuneration. Next up, we have Talita Laubscher. Hi, Talita. Give us a wave. Talita is a partner in our employment and benefits practice area in Johannesburg. She is also a data protection specialist. Again, she regularly advises top South African companies on employment consequences of commercial transactions, and is also at the forefront of data protection developments and advises extensively on POPIA, which is going to be pretty useful for us today. Next, we've got Kelly Wright. Kelly, give us a wave. Kelly's a partner in our tax practice in Johannesburg. She has a specific interest in structuring M&A transactions, and of particular importance for our panel today, she's got extensive experience when it comes to schemes of any nature. Last but not least, we have Ntokozo, who's here. Ntokozo is a partner in the M&A practice area with me here in Johannesburg. She's got a broad range of experience in corporate and commercial transactions. And most importantly, she's been advising a number of our clients on the proposed amendments to the Companies Act. So she brings a big value add to this group. Okay, now that you know who everyone is, as you know, some of the recent amendments to the proposed Companies Act place remuneration very much in the spotlight, which is obviously what we're here to discuss today. Perhaps how we can start is I could hand over to Ntokozo, who will set the scene, explain what these changes are about and how we need to go about implementing them. Ntokozo?
Thank you, Misty. I think for additional context, it must be mentioned that a previous set of proposed changes to the Companies Act were published in 2018. And in the 2018 amendments, a requirement to prepare a director's remuneration report was introduced, which report was to comprise a background statement, an overview of the company's remuneration policy, and an implementation report dealing with and an implementation report detailing remuneration and benefits, and this director's remuneration report under the 2018 set of amendments was required to be approved by the board and then presented to the shareholders at the AGM. What we've seen now with this new set of proposed amendments is that, firstly, it seems it is only required to be prepared by public companies and state-owned companies. And it also introduces a distinction between the remuneration policy and the remuneration report. So the REM policy itself pertains only to directors and prescribed officers and is a very distinct part of the REM report. And in addition to the REM policy, the remuneration report must also include a background statement, which is similar to what was contained in the 2018 bill, an implementation report containing details of benefits received by each director or prescribed officer, again, similar to the 2018 bill. But in addition to that, the total remuneration of the employee with the highest total REM, which includes salary, benefits, short-term incentive awards, such as bonuses, long-term incentive awards such as share options and any other type of long-term scheme incentive awards that may have been settled in the relevant year. And it must also include the total remuneration of the employee with the lowest total REM in the company. Again, this must include all salary, benefits, incentives, etc., as recorded in the company's payroll. And also in addition to that, the average remuneration of all employees, median remuneration of all employees, and the pay gap reflecting the ratio between the REM of the top 5% paid employees and the total remuneration of the bottom 5% paid employees must be included.
And Ntokozo, maybe you could run us through how these are approved.
Sure. So the REM policy is approved by an ordinary resolution at the AGM, and every 3 years or whenever a material change to the REM policy is made. Not much guidance is given at the moment as to what would be material under the circumstances. And the Companies Act definition of material, which means significant under the circumstances of the particular matter, to a degree that is of consequence in determining the matter, or which might reasonably affect a person's judgment or decision-making in the matter, doesn't feel as appropriate or quite particularly useful under the circumstances. And further, any changes to the, apologies. Do you wanna? Okay, apologies for that, technical difficulties. So I was saying any changes to the REM policy may be implemented once shareholder approval is obtained. So the REM report itself must be approved by the board and then presented to the shareholders at the AGM, but this time for approval by ordinary resolution. And the implementation report must also be approved by ordinary resolution.
Martin, at this stage, it might be a great idea if you could jump in. I think one of the topics that is worth discussing is what the intention is really behind these proposed amendments. I know that we've spoken about this offline and together with Talita, maybe we could start with you, Martin, on some of your thinking around this, and then Talita, if you wouldn't mind jumping in.
Yeah, thanks, Misty and colleagues, and hi to all 186 people that have logged in so far. A number of people I've known and worked with, so nice to see you as well. So what is the intention of this? So we know globally there's a lot of emotion around executive pay, and I think particularly in South Africa, which is known to be a very unequal society for a number of reasons, legacy issues and current challenges that we have. So many stakeholders, including organized labor, the press, the government of the day, and in some cases, institutional investors are not happy with the quantum and nature of executive pay, particularly compared to the average pay or the lowest paid people in our country. So I think that's the concern, and it's stated very bluntly and straightforwardly in the preamble that this is really targeted at excessive executive pay. And I must admit, having to deal with executive pay in my day job and working with a lot of large remuneration committees, it is very difficult to define or deal with what is excessive pay. And I think there's at least two perspectives. There's many perspectives on excessive pay. From the institutional investors' point of view, who are given the power in this act to remedy what is believed to be excessive remuneration, it's generally a remuneration which is not aligned with the interests of shareholders and their proxy interests as asset managers, which basically says if it's not aligned with the creation of value or company performance, then it's excessive. And particularly because this is quite codified, and there's a couple of big agencies called proxy voting agencies who give guidance to shareholders as to how they vote. They have quite a formulaic, sometimes we unkindly say tick box approach to this. And if you color outside the lines of what these, let's call them the international REM police have to say about remuneration, then that is deemed excessive or inappropriate. So that's the one set of things, large payments for exiting employees or executives who've deemed not to have done a good job, large payments when the performance of the company has been bad, coloring outside of the lines of these fairly self-appointed guardians, that's what's deemed to be excessive. Then the other set of stakeholders are organized labor, government, NGOs, activist shareholders, which have started becoming very influential, particularly on carbon credits, etc., and carbon emissions, but also on remuneration of late. That's just deemed the quantum and the ratio between normal people, if you like, and low-paid people in the country, because those ratios are very high. And I must admit, although I deal with these numbers every day, I do understand when somebody's paid hundreds of times, sometimes more than a full-time, hardworking person. I get it. I do understand that. But as we'll unpack, this has got to be dealt with very carefully. And as I repeat myself many times, we're between rocks and hard places in terms of this understandable emotion about executive pay. And let me not dismiss it. It is a very intense emotion. It's got something to do with rebuilding trust between business, government, stakeholders. So that's very important. But also being practical and being able to run these enormous companies which look after tens of thousands of employees, billions, sometimes trillions of rands worth of assets. And if they're well led, can be part of the solution and the journey to inclusive growth, building fantastic economies, hiring and employing lots of people, and failure. We've seen people who either maliciously by criminal acts destroy companies, or inadvertently because they just haven't spotted something or haven't had the skill to do it. So I think that's the rock on the hard place. How do we deal with true excesses of remuneration, and how do we deal with balancing this so South African business can thrive and function? So that, Misty, I think that's really probably the intention, but I think we've got to always be careful of unforeseen circumstances and perverse consequences of sometimes well-intentioned actions.
Thanks, Martin. And maybe before we go over to Talita, maybe you could explain some of the global trends in terms of trying to address this situation in some other jurisdictions.
Yeah, this concept of shareholder voting and consequences for directors on RemCos is quite widespread. So there's two main provisions which are applied in this context of shareholder vote. And the one is the binding vote on the remuneration policy. And I think, as Ntokozo mentioned, there's two very distinct things. And the one element, I'm kind of cautiously optimistic. I'm worried that it could go horribly wrong, but I'm cautiously optimistic that it can work. And there's one provision that, in my humble opinion, really doesn't work. So as Ntokozo said, there's the vote, and that's a binding vote. If it's an ordinary resolution, it is only at 50%, but we have seen some real crash and burns on votes that have been well below 50% of late. So it's a real risk of that not happening. So that's the policy, and that needs to happen at least once every 3 years, or that rather confusing point of when there's material changes, which we'll unpack a bit later. So that needs to be done. And that's in line almost word for word with the United Kingdom approach to reward remuneration, and it's largely workable. Has it dramatically decreased executive pay? No, it hasn't. So just cautionary note to the policymakers. This doesn't dramatically decrease executive pay. It does mean there are hard boundaries. It does manage some aspects. Then there's the Australian approach, which is the so-called two-strike rule. So when we talk about two-strike rule, that's what happens in Australia. They don't have a binding vote on policy. They have something like what we have, which we'll explain a little bit later as well. If there's a vote against any policy, the policy or the implementation report, then the directors responsible for that policy and implementation, being the Remuneration Committee of the board, have to stand down for re-election, but only after 2 negative votes against the policy or the implementation report. So that's what's called the two-strike rule. 2 strikes and you're out. Okay, or you're not actually out, you stand down for re-election. Interestingly enough, when the RemCo gets spilled, as they call it, they get spilled off the board, most of the time they've actually got re-elected back. So one does start wondering, what is this all about? So those are the 2 mechanics. And just more broadly, what other things have happened to rein executive pay? There's the attempt, and again I'd say attempt, at reining in bankers' pay. So we all recall the 2008 crash and many of the big global banks being bailed out by governments and taxpayers, and therefore there was a huge reaction to excessive pay, and there really was excessive pay. What our South Africans get in rands, people were getting in dollars plus another 0 sometimes. So that was really, really big numbers. In that case, there's a regulation of financial services, particularly banks, which is called the CRD4, I think Capital Requirements Disclosure 4, which capped the amount of incentives to, in Europe, 1 times the base pay, the guaranteed pay, and in the UK by shareholder vote, I think 2 times. But basically what happened was that the base pay just doubled to kind of ensure that executives were still getting similar remuneration. And intrinsically why? And this is a bit of a health warning for ourselves, because you had bankers in New York and Boston and Chicago that were not being capped, and you had bankers in London who were being capped. So you could work in London or New York if you're a real big deal. So a provision had to be made so that you could offer competitive pay. And competitive these days means in a global market. And don't forget, South Africa is in a global market for executive talent. We've got very skilled people. We're quite resilient. We're quite adaptable. We work in quite challenging conditions sometimes, and we can work anywhere in the world. So that's just the concept. And I know it's very controversial saying, retaining executives and do we have to have talent to run our businesses? But, that is a reality. We don't work in a vacuum. So Misty, those are the sort of 3 things. So binding vote on policy, a la the UK, 2-strike rule, a la Australia. And if we go with the vote on the implementation report that Ntokozo didn't quite spell out the enormity of, not only is it a binding vote on the implementation report, but then 1 strike. You get 1 vote against that implementation report at 50%. Then it's a little unclear what the act means, but it says that the directors on that committee have to step down for re-election. So you spill the RemCo on one strike. So that's where I have some quite serious concerns about the practicality. A binding vote on the implementation report that I think we'll unpack on the panel. What does that mean from a legal perspective? And 2, the very onerous consequences for RemCo members, which, by the way, is not shared by members of a social and ethics committee if there are 100 fatalities at a mine, nor shared by an audit committee if there's 100 billion fraud. Explicitly, obviously, there would be serious consequences, but not explicitly. So just, focus on executive rem, fine, and it's a big issue, but is it proportionate? Is it symmetrical across other governments? I think that's some of the things I'd like my colleagues to unpack a little bit. So thanks, Misty.
Thanks, Martin. I think one question that's already come up that I think is useful to go back to before I move over to Talita, and Ntokozo, this is really for you. Which companies do these amendments actually apply to? Does it apply to public and private companies, or only a particular class of companies?
Sure. So on the reading of the Act or the proposed amendments, it seems to apply to public companies and state-owned companies.
Okay, thanks. I think that's helpful to get out of the way before we move on. So we're really only at this stage thinking about public companies and SOCs. Back to the intention behind the proposed amendments. Talita, it might be useful for you to come in here and maybe speak about the kind of impact on employment and unemployment more particularly, and the positive intention behind some of these amendments in that regard.
Thanks, Misty, and good morning, everyone. It's great to be a part of this webinar and great to see you all. Yeah, it is interesting, and I think it is very important that the legislation is aligned across the various departments that oversee that. And the Employment Equity Act, of course, contains an obligation on designated employers to report on the wage gap. Designated employers include public companies and private companies, and the report on the wage gap in Section 27 is therefore not really new. It's been there for as long as the Act has been in force. Now, the Employment Equity Act seeks to give effect to the right to equality in the Constitution, and it does that in relation to pay in two ways. The one is to make it illegal, or there's a prohibition on unfair discrimination if the two people or more that are being compared are treated differently because of unfair discrimination. So if the reason for the difference in pay is unfair discrimination, then you have a problem under Section 6.4 of the Employment Equity Act. If the reason is unrelated to unfair discrimination, like seniority or length of service or performance, then you avoid a finding of unfair discrimination. And similarly, if the jobs are not the same or similar or of equal value, then you will avoid that finding of unfair discrimination. So that is the one way in which the Employment Equity Act deals with unequal pay. The other way is, as I said, Section 27, and that section applies only to designated employers. So those are the employers who are bound by the affirmative action provisions of the Act, and together with their annual report, they must submit an income differential statement to the National Minimum Wage Commission. And in that statement, Form EEA4, they need to set out quite a lot of detail in relation to the remuneration paid to employees. And again, the remuneration there is very widely defined. It includes your basic pay and your variable pay. And perhaps that is something that we need to keep in mind when we are thinking about the Companies Act amendment in relation to what would be required, because of course you would want to have alignment between these different acts. Then the Act says, interestingly, that where there is a disproportionate differential, the employer needs to take steps in order to rectify that. It doesn't say what is a disproportionate differential. It also curiously says where there is unfair discrimination, you must take progressive steps to address this. Under the first chapter of the Employment Equity Act, claims for unfair discrimination can be fixed immediately. So why would there be this obligation to progressively take steps in order to address this differential, which perhaps, shows a little bit of the dilemma that we are talking about. We're talking not here in the wage differential about people performing the same work or work of equal value. It is really the wage gap between the top and the bottom and everything in between. And the Act suggests that you achieve the more proportionate differential by way of collective bargaining, by way of benchmarks that the National Minimum Wage Commission should set, by way of skills development. Interestingly, the National Minimum Wage Commission hasn't really set any benchmarks, not from what I can see from the website. And therefore, it is very difficult to know what really is the disproportionate differential for purposes of the Employment Equity Act. So yeah, it is interesting. The form that you need to fill in needs to give you totals. So you need to give the total of remuneration paid. You also need to then go into more detail, the highest and the lowest in respect of race and gender and foreign nationals. Then you need to say what is the top 10%, which is also again a little bit different from the proposed amendment, which refers to the top 5%. And you need to then also indicate the median. And there needs to be a policy to address the gap. And you must say what are the reasons for the gap. And how many times is the lowest getting lower than the highest? Is it 10 times, 100 times, 200 times, whatever the case may be? So that information is already gathered through this process of reporting. It is not a public document, as would be the case with the proposal under the Companies Amendment. Exactly, what is done with that information isn't clear, but I would imagine that that is the basis for the research of the National Wage Commission in order to set the benchmark. But yeah, that is already there, and that obligation already exists. As I said, not only in relation to state-owned entities or public companies, but also private companies, provided they are designated employers.
Thanks, Talita. I think one of the points you've raised is a helpful step to actually link to the proposed amendments here, and that is whether or not, and you pointed out that it is correctly so, whether or not the information is publicly available. And Ntokozo, maybe you could jump in here and maybe speak a bit more to that together with Martin in terms of the REM policy being publicly available and what the consequences and potential consequences of that might be.
Sure. I think also for context, again, referring to the 2018 bill, amendments were proposed which would have had the effect that shareholder communication, so essentially notices, minutes, resolutions, documents that you share with your shareholders in relation to resolutions, and really any communication to holders of a class of shares could be accessible to members of the public on application to the company. And in the context of REM discussions, this would mean that all information shared with shareholders in relation to the proposed resolutions to approve the REM policy, the REM report, the implementation report, and of course the policy and reports themselves could constitute shareholder communications. And however, what has since happened in the 2021 bill is the subsection dealing with shareholder communications was not specifically included in the list of information that third parties could request from a company, but then a new subsection was included, which then provides an exemption for certain categories of private companies from being required to disclose shareholder communications, which then creates an impression to suggest that there may have been an intention to retain that proposal, that shareholder communications be accessible to the public. And we are making submissions in this regard just to get confirmation and clarification around that specifically. And I think it should also be noted that, aside from that, financial statements of companies that are required to be audited must already include particulars showing the REM of directors and prescribed officers, and this would include information relating to salaries, your bonuses, share schemes, fees, and various other types of remuneration generally. And, the 2018 bill went further and even proposed that each individual be named. So it would actually be quite specific REM information that would be required to be included in the financial statements. And then as a next step, the annual financial statements themselves have to be filed with the CIPC when you file your annual return as a practical point. So, and it should be kept in mind that once you essentially make a submission to the CIPC, those documents are effectively rendered to be public documents.
Can I come in there, Misty and Ntokozo? So I think it's quite important, the subtlety here. There's changes to section 30, which in this current bill says exactly that if the prescribed officers must be named. It's quite explicit about it in this current version of the bill. And my understanding is that section 30 would apply to companies that need to be audited. So obviously that's the big and bad ones are listed and the SOCs, but also companies that have a public interest score of above 350, which scopes in quite a few decent sized private companies. So as I understand it, that they will now have to put out a remuneration report, as they've had to have done previously, but individuals must be named. And then via this sort of left hook that's coming from the bill as well, that there's a huge amount of accessibility by Joe Public to those records as well. So certainly in some other discussions, not exactly focused on executive remuneration, but the remuneration now are probably tens of thousands of people that are directors of significant private companies will become accessible via that with all the risk of privacy issues and that we have. So I think let's note that just the combination of this named individuals, which is not just public companies and the SOCs, but to every large private company. And then you're absolutely correct that the things we were talking about, the binding vote on the policy by shareholders, the binding vote on the implementation report, that's in the section 30A, which is applicable, quite clearly applicable to public companies and to SOCs. So there's subtleties to this thing and unintended, maybe intended consequences, but certainly consequences, capital C, to corporate South Africa in that regard. And then just while I'm on song, just Talita, the pay gap story. So again, this is something which there's a lot of sensitivity about. There's requirements to disclose. And again, this is not a South African precedent per se. The US for quite a long time now has had an act called the Dodd-Franks Act, which has required the gap between the CEO and the median of everybody else in the company. And by the way, if you look at those records, just to address some of the conceptions that from a corporate pay gap point of view, we're the worst in the world. The US beats us on that, well, by far. I think the highest pay gap was actually Weight Watchers International, but I think a certain Miss Grossman, interestingly named for the organization she runs, has a pay gap of something like 2,000 or something like that. So it's really, really huge. But so there's been quite a lot of debate with Buza, organized labor, etc., about what is the ratio. So when we report this thing, what is the ratio? So we started off many years ago looking at the Gini coefficient for companies. And I think because we always start the narrative, we're the most unequal society in the world. We have the highest Gini coefficient in the world. Fact. It ranges between 63 and 73, depending on what source you look at, and that's very, very high. I mean, developed nations are around in the upper 30s, the Nordic nations are in and Asian nations upper 20s. And it's a bit like the Richter scale. As you move up, the unfortunate register gets much, much worse. So that's correct. We have a huge inequality at that level. But if you unpack that, a huge chunk of that is the effective, 40% upwards of people that are unemployed, earning nothing, or just the state subsidies and stipends. So that is a huge impact. And something I did when I was at PwC several years ago was to unpack what's the corporate Gini coefficient. And at the time, that came to 43 or 0.43, which is orders of magnitude less unequal, sorry for the double negative, than the national one because of unemployment. And I think that to me started pointing to where do we go with this thing? There's no solutions. We're between rocks and hard places all over the place. But where do we go with this thing? We have to get more people employed. We have to pay those people that are employed a decent wage. And it's the point that you have, what is a decent wage? What is a living wage? So what is the policy for if I'm a big bad company paying my executives lots of money, what do I pay my lowest paid permanent employee that allows a living wage, a frugal but dignified lifestyle? So, I can look after my family and myself. And I think when we get to where do we really go from here, there's all of the machinations of this act and various agendas and intentions behind that. But if you really take a step back, and what does a well-intentioned big corporate do? And I think what you pay at the bottom is very, very critical. And to me, that's what it's got to inform what you're doing. If I'm an executive getting 30, 40 million, I think I've got to think about what my most junior person is paid, and that they can at least live in a brick house and send their kids to school and give them enough calories and give them the opportunity to maybe be the CEO of my company in 20 to 30 years' time. That to me, maybe I'm naive about that, but I think that that's a valid way forward. So I think in two focus areas. We look at what we have to do to comply and where this act lays up to good conscience, paying the people we do hire a decent wage at the bottom, whatever that may be. Do all the research and all the thinking about that. Be very careful at the top. We have to pay market. I think with all the intentions, I don't think we can slash executive pay in South Africa, as many stakeholders would love to see. But I just don't think we can do it, because we're already at a tipping point of our executives being rewarded versus international executives. And we have to pay market. If we don't pay market, we're just not going to get and keep the people that we need to actually grow our businesses and hire everybody. Then the second thing, the third thing, so pay the people at the bottom reasonably and try and pay them more if you can, because I think they're a vulnerable group of people. Be careful at the top, pay for pay and align with performance, don't pay for failure. I think if we do that, institutional investors at least will be happier. Don't think I'll ever be happy. And I think that's, and then the other things, grow our business and hire more people. So we've got to tactically go for growth in economics that sucks in more people and hire people in great jobs. This whole digital opportunity of, we don't really want to create jobs like the bad old South Africa did in menial and dangerous and horrible environments where we get paid very little for working long hours in dangerous places and doing mundane things. But with digital jobs and the new generation of jobs, the whole new world of work, I guess that we need to get them trained, get them enabled, get them capacitated. So we will delightfully pay them a really great wage because they're doing fantastic things for us. You know, so I think that's, sorry for getting a little philosophical, but somebody told me the other day I've moved from being a mathematician to being somewhere between a psychologist and a philosopher in pay these days. But that's where we've got to go.
Yeah, and the thing is also, it's not one thing that needs to be fixed. There are lots of systemic issues here. It's training, it's education, it is a whole lot of things that need to be addressed. And one does have a concern that, you know, this might be seen as the silver bullet that is just going to fix everything, while actually it's a systemic problem that we need to be aware of.
Misty, if I may just bring in Kelly here. There's actually one optimistic point and one bright point on this fairly scary bill. And that clarifies one element, I think it's clause 17 of the bill that defines what is an employee share scheme. So, Kelly, maybe if we could just ask to...
Sure, Martin, maybe to take a break from very heavy philosophical issues and some of the negatives in the proposed amendments. There is one very simple point. It's a positive point, and it's very clear. It is clause 17, and basically it amends section 95, a definition in section 95 of the Companies Act. And basically all that is it changes the definition of what an employee share scheme is. Previously, an employee share scheme was a scheme established by a company which involved the issue of shares in the company or the grant of options. It's now been expanded to also involve the purchase of shares. Why this is important is because if you comply with section 97 of the Companies Act, which is basically appoint a compliance officer to do certain things, you fall within the exemptions from some of the financial assistance provisions, so section 44, section 45, and you don't have to get a special resolution to implement your employee share scheme. This is crucial for most companies who obviously just don't want to do that every time they want to make a share award. And so we'd actually been giving advice for a number of years on the basis that the definition in section 95 is too narrow and should be interpreted as having included market purchases of shares as well. And this proposed amendment was included in the 2018 bill, and we think it just clarifies what is the only reasonable interpretation of the section. So it's good. It just says if you have an employee share scheme, whether you settle by market purchase, issue, use of treasury shares, whatever, if you have a compliance officer and you comply with Section 97, you get out of the financial assistance provision. So that's great. What's important is that it's caused a little bit of confusion because people have raised a question, what does this mean for if I'm a listed company and I have a non-dilutionary scheme, meaning I settle my awards by buying shares in the market? Do I now fall within the JSE listings requirements? So just to take a step back, Schedule 14 of the JSE listings requirements governs employee share schemes by listed companies, but it only applies to dilutionary schemes. So if I settle by issuing shares or using treasury shares, if you settle your employees by market purchase, the provisions of Schedule 14 do not apply to you. This amendment to the Companies Act to broaden the definition of employee share scheme from Section 95 has raised a lot of questions. Does that now also apply to the JSE listings requirements? Does that mean if I have a non-dilutionary scheme, I fall within Schedule 14 and I have a whole world of other regulatory requirements? And the simple answer is no. Those are two different sets of law. Schedule 14 is distinct from the Companies Act amendment. This amendment is just good and simple and clear and helpful, and does not mean that if you have a non-dilutionary scheme settled by market purchase that you now have Schedule 14 applying to you. So a small bright spot in quite a tense discussion otherwise of complicated and unclear provisions, and hopefully an easy takeaway.
Thanks, Kelly. Hopefully it's not the only bright spot. I think what we've covered here is that there are definitely some good intentions behind the amendments. And we're going to get to some of the consequences later on as well. But I did want to go back, Talita, if you don't mind. We spoke briefly about the publicly available aspect of the amendments and the potential impact of that. Is there a popular kind of argument to say that making all of this information publicly available is a problem, or is that a pipe dream?
Yeah, Popia says you can process the personal information of data subjects on various grounds. So you can do that with their consent, but that is not the only ground on which you can process personal information. If legislation requires you to do that, then you are permitted and then in fact obliged to do so. So I would imagine that companies would rely then on the Companies Act if this comes into force and say that they are obliged to make all of this information public together with the names of the individuals concerned. And, you know, that is how the legislation is permitting them to act, and that is then a limitation on those individuals' right to privacy. In the event that there is a complaint about that, one would need to consider whether that is in fact a reasonable limitation and whether it does perhaps go further than what is actually needed. And that would be very complex litigation. But if, yeah, the principle is if legislation permits or obliges that disclosure, then under Popia it will be in order to do so.
So yes, it is a pipe. Talita, while you're the questions that's come through, and maybe this is something for you and consider, is whether you've got any thoughts around the level of detail required with respect to particularly bottom level pay analysis, and whether it's going to be sufficient that we just propose a skill or a qualification, or whether we need to get into more detail. And I think something that's worth considering in this context as well is where we are disclosing pay of the lowest paid employees, what kind of behavior that might drive in terms of potentially outsourcing that work. So two prongs there, Talita, if you don't mind.
Yeah, look, the Employment Equity Act is quite clear on the level of detail that you need to provide. And that is all basically the cost to company to that individual. And That's basic and variable pay. There are very small exclusions that apply, but variable pay is certainly included, also in respect of your lowest pay employees. Yes, the Act itself recognizes that pay gaps may be addressed through collective bargaining, and that would mean the involvement of trade unions. Of course, if a trade union wishes to get this information, it can get this information through PIA, the Promotion of Access to Information Act. In the event that it is a private company that is the holder of this information, then that request needs to be accompanied by an indication of what is the right that is sought to be protected here. And it is difficult to say what is that right, because definitely there's a right to equal pay for work of equal value, because that goes to the formal right of equality amongst people who are similarly situated. In a wage gap scenario, it is a little bit more difficult, but I can see a claim being made on the basis that we want to address the disproportionate pay, and that is why we are wanting to get this information. And that must then be provided probably on an anonymized basis, and the parties can then engage in collective bargaining about the pay differential. Of course, if this information is publicly available, that route doesn't need to be followed, and the unions can just simply access that information from the public record, which would then, make for very interesting wage negotiations and probably considerable demands for increases at the bottom.
Just to that point, and Talita, to maybe just draw this out, we know that there's been a lot of debate about what metrics do we use? Do we use, pre-tax or post-tax? A lot of executives, very senior executives, the bulk of their pay is actually long-term incentives, and it's conditional upon KPIs being met, employment conditions being met. And so there's been a lot of back and forth about how do you determine what the highest pay was? How do you determine what the lowest pay was? And the sort of cynical lawyer in me sees a lot of room here for abuse and for sort of schemes to get around that. On the one hand, we know during COVID, a lot of long-term incentives did not vest. So if you were to say that the maximum possible award that someone could get, the maximum pay, it's not a realistic perception of what people are getting paid. On the other hand, we could see people, as Misty sort of hinted at, if we're having to disclose the pay of our lowest paid people, we could just put them onto special contracts to make sure that that's not really an employee, or we're going to outsource that, or to try and get around this requirement. I mean, have you got any insight, Talita, into what would be the most reasonable, maybe Martin as well, what would be the most reasonable way to try and come to a fair and realistic comparator of what are people actually getting paid at the top end and at the bottom end, and to try and sort of circumvent some of this abuse that I can definitely see happening.
Misty, maybe if I can take that. So we had quite a bit of a debate with the employment equity folks that are responsible for the EEA4 form, and some quite useful developments in terms of some guidance notes that they put out there. So just some sort of executive pay 101. There are many different versions of pay that you can quote, particularly at the top. And these have come into the King 4 and the JSE parlance. So in terms of the remuneration policy, probably one of the most useful versions of pay is what we call on-target pay, which is what the STI is worth if you hit your targets, not necessarily your maximum you could get, but a reasonable expectation of targets. And for the long-term incentives, it's the at-grant annualized fair value, which means basically what do you expect to get at the sort of current share price out of your long-term incentives. And that's quite a useful concept. And my personal view, and a number of people in my profession, is that that's quite useful for setting policy pay. Because if we really want to genuinely use this as a means of evaluating, understanding the pay gap and decreasing it to some extent as we go into the future, then policy pay is the best mechanism. Because I think what some of the stakeholders don't get is that if we look at payroll pay, what goes through the payroll, what gets taxed, which is the other version of one of the other versions of pay that we can look at, which is true in a sense, because that really is cash flow that's going pre-tax, that's going to individuals. Trouble is that's very variable for the top of the house, because depending on when long-term incentives vest, when options are exercised, what the share price is, you've seen the mining industries have been on a wonderful bull run. So the next year or two, there's great reflected pay or payroll pay, but then in some years there's nothing that comes out of those. So you'd see a variation. Let's say the multiple was 100. In a bad year, it might be 30 because 60 to 70% of top executives' pay is variable. And in the other year, if everything vests and the share price is quadrupled, as we've seen in some of the mining companies, then suddenly it's 300. So would you say, because it's gone from 300 to 30, the policy has changed and the pay gap has narrowed, or vice versa, 30 to 300? No, it's just the vagaries of the market. So if we genuinely want to track pay, then on-target pay is useful. So I would say the top 5%, top bottom 5% range, I think the definition of that, if we used on-target pay for that would be appropriate, because that seems to be the pay gap measure that wants to be made. I prefer something called the Palmer remuneration ratio. That's the top 10% divided by the bottom 40%, which there's all sorts of development economics. It says that's a great thing to track if you're dealing with inequality. But I do know there's already been a lot of arm wrestling with organized labor, and they want a more extreme measure, which is the top 5, bottom 5. So I think that horse is bolted, and it probably gives a similar trend. So I'm okay with that as a ratio. Not the best, but I'm okay with it. So if we use on-target pay for that, and the bill does talk about it in some of its last paragraphs, there's debate between Labour and business about should we use on-target pay. They use that term versus payroll pay. Then there's another type of pay which is also difficult to get around, because if people do want to be Machiavellian about it, because it's audited, there's a King 4 and there's a JSE listing requirement. It's this concept of total single figure of remuneration, which is closer to the actual pay realized, but there is a timing difference. And that is that if your LTIs, long-term incentives that are being measured, are reflected in the year that their performance is measured. So if you have a typical 3-year performance share that vests maybe 3 months after year end when you've measured the performance, but is measured on the year end, total shareholder return, earnings growth, it's reflected, but like accounting accrual in that year. So the payroll pay would show 3 or 4 months later in the next financial year. The total single figure shows it when it's accrued. And the aspiration around that is that investors could see what is the person's pay, executives pay versus what the performance of the company is. So that is quite confusing. There's another 3 or 4 variants of pay, but basically payroll pay, what goes through the payroll in cash, on target pay, which is good from a policy point of view, probably the most realistic way of saying what's the pay intention over a very long term, and then total single figure of remuneration. For the most junior people, I think payroll pay is fine. They're not reported in the public document as total single figure. And there's one other thing that's come up. A lot of very progressive employers create great benefits for their employees, like various subsidies that are not necessarily taxable, or transport, or other good things that they do for the employees, which is not reflected in that bottom wage. And a couple of progressive companies said, actually, in our pay gap, we should, reflect the aggregate benefits that the company pays for, is but not necessarily reflected in payroll pay. I think that's going to be difficult to monitor, and it's aspirationally okay. I don't think we're going to be there, but just an interesting point to note on that. So those are the various things. I think the 5-5 ratio probably on target, just because people do want to know, shock horror, what the top person got and what the lowest person got. I think we're probably going to use probably total single figure of remuneration or payroll remuneration for that point. Who got the highest pay, who got the lowest pay, because there seems to be a morbid interest in those particular numbers.
Martin, maybe on that point, and sorry to interject, but one of the questions that has come up is that while the proposal to use on-target pay is certainly acceptable to the corporate community, can we assume that that's forming part of our feedback going back to the relevant legislature, and do they understand this, and is it likely to be accepted that that's the measure that we use?
Yeah, so certainly all the various bodies that I've been involved in, the Institute of Directors, the King Subcommittee, the South African Award Association, we've all mentioned that we believe on target pay is useful for that, and the unintended consequence of payroll pay means that it's too volatile. So that's definitely part of the feedback that's gone through from a number of the bigger remuneration bodies. It's not acceptable to Labour because they just don't believe it. They think it's a Machiavellian mechanism to understate pay. So there's still going to be arm wrestling, but obviously because the debate has surfaced and it's not a done deal in the bill, possibly the powers that be that are drafting this are at least sensitive to that.
Thanks, Martin. That's helpful. I mean, maybe it's the right time to ask another question that's come up, and I am aware that we have so many topics still to cover, but given we're on this point already, one of the questions that's come up is, in correcting unfair discrimination, would one have to backdate the pay? And what impact will backdating that have on things like retirement contributions or incentives already paid? Is that something you foresee as having to happen?
Well, that will only be the case where there's unfair discrimination, and we now need to bring the two comparators in line. And normally the courts deal with the issue of the remedy and how long that is backdated for, and or not at all. So if that is a measure that is embarked upon by the employer, for example, in collective bargaining with its unions, that is something that can be agreed with the union or with the individual employees themselves. But yeah, if there is long-standing unfair discrimination, that is something that the courts do consider. Misty, perhaps if I can just come back to the question on, is there not a risk that we will just see a lot of outsourcing at the bottom? That is, of course, a risk, but there is a safety net for employees who provide work to a client through a labour broker, and they earn below the income, the threshold of around 212,000 rand a year. Those employees may be deemed to be the permanent employees of the client to whom they are provided, and they can also be deemed to be the employees for the Employment Equity Act purposes, dealing with the income differential statement. So it's not a foolproof strategy to just simply outsource your workers and to get them back through a labour broker. One needs to be careful of that being in provision in the LRA.
But I would imagine, maybe to test this more for myself than anyone else, but maybe other people are thinking this too, Talita. I would imagine that whilst that impacts from an employment perspective, that potentially from a Companies Act perspective, you would still be able to have those outsourced employees fall out of this calculation, right? So we don't move away from the employment consequences potentially and reporting under the EE Act, but we do find ourselves in a position to exclude those individuals from the calculation under the Companies Act.
Yeah, absolutely. And then the question is, does it make sense not to have alignment between the two acts? Exactly.
I think there are a few questions that we'll get back to further down the line, but I think this is a good point to move on to you and Ntokozo to speak particularly about the consequences of non-approval. I've seen a couple of questions coming through about this. What does it actually mean if the resolutions aren't passed? And we can, as a group, talk about both the intended and unintended consequences of that. So, Ntokozo, can I hand over to you?
Sure, thanks, Misty. So when the REM policy is not approved by ordinary resolution, it must be presented at the next AGM or another meeting called for that purpose, basically until approval is obtained from the shareholders. And you'll also recall that I mentioned earlier that any changes to that REM policy may only be implemented once shareholders' approval is obtained. So that can present some practical difficulties. And if the implementation report is not approved by shareholders' ordinary resolution, then the REM committee or the directors responsible for remuneration matters of the company must, in the next AGM, present an explanation on the manner in which the shareholders' concerns had been taken into account. And also the non-executive directors that serve on essentially the REM committee will be required to stand down for re-election every year of that rejection, or of such rejection of the implementation report. So every year that it's rejected, the non-execs need to stand down. And on our reading, the wording is not very clear on whether the non-execs would stand down from the REM committee only, or if they would have to resign from the board generally. And if it's the latter, this may potentially have unintended consequences that other committees that they serve on as independents and non-execs may now find themselves not quorate anymore because they would have potentially resigned from the board.
Yes, and I imagine. Sorry.
Kelly?
Because I was just going to add that aside from sort of the technical issues with directors having to stand down, there's a lot of concern about what happens if the implementation report itself is not approved, because of what that report does for REM issues. So it's an outcome of the remuneration policy, and it's retrospectively approving what we have done throughout the year. And there are huge concerns because it is quite vague. This is a vote on increases, on STI awards, on long-term incentives that may go back 3 to 5 years that have already been paid. It covers a huge amount of stuff. And so there's concern that if the vote fails, what does that mean? Does it mean we have to have employees refund some of their short-term incentives or their long-term incentives? I mean, it's not possible. It also goes against a lot of employment law, potentially also the Constitution. So, I mean, Martin spoke very strongly against why there is a lot of industry pushback on this vote on the implementation report. But from a contract law, from an employment law, from tax law, many angles, this is hugely problematic, because we have a report where we're just saying, this is stuff we have done. It has been paid. The ship has sailed. We're informing you. And we're also concerned that this could have huge consequences, because perhaps a shareholder is unhappy with one aspect, probably something like the CEO's pay, but they will vote down the entire report, which could have an impact on the lowest paid employees, for example, a minor increase or a small short-term bonus. And you would not be able to pass that out to say, I want to vote yes on this and no on that. It would just fail entirely, I mean, as things are currently drafted. So I think, not to try and be very dramatic, but we are very, very concerned by the implications from a legal perspective. If you say anything we do in our REM implementation report could be reversed, what are the consequences practically for employees and directors? Martin, I'm sure you have more to add on that, but I just wanted to flag it all on this point.
Kelly, I think you articulated it very well, and that's a real legal consequence, and I think there might have been an unintended consequence of stating that the implementation report is voted on as an ordinary resolution. I think hopefully the intention was that it's voted on with a trigger of 50%. And if there's a trigger of the 50%, then the quite onerous consequence of the spill of the REMCO, which I also think probably means that the directors have to stand down from the board, because the REMCO isn't a statutory committee whereby you voted on by the shareholders. You're appointed by the nominations committee of the board to serve on that committee. So if you have to stand down, statutorily, you can only stand down as a director and be re-elected. And the point that you and Ntokozo made, there are a lot of chairmen and chairladies of companies that sit on the REMCO. They don't ever chair them because of King 4 and listing requirements matters. But a lot of them sit, so now suddenly you spill the chairman as well, with all the unintended consequences of that. And as you say, a whole lot of committees in court. So this will be deeply disruptive to South African governance and business. That, retrospectively having to approve things which have been done, or delaying the implementation of these matters to the AGM, but then not knowing whether you can settle your LTIs. That Kelly said, they're contractually binding matters, as I understand them. When you issue that letter, you don't have much discretion anymore. There's the rules of the plan. You apply your discretion to make the award and set the performance conditions, then it's pretty binding as far as I understand it. So to be precluded by your shareholders from settling something which is within the policy and a contract that the company has made, I think that's deeply problematic. So I see huge practical problems of the way it's articulated. It's approved by ordinary resolution. I think if it was said that it's approved by a non-binding advisory resolution of 50%, and then the consequences, and we can debate the consequences and the consequences of those consequences. Explaining to shareholders as to why you've done what you've done, that gets done anyway with the current regime. And maybe let me just pause. I think we sort of tacitly assuming that everybody knows what the current situation is. So just to remind everybody that the current situation is that there is a non-binding advisory vote at the 75% pass mark, or no more than 25% of those voting against dissenting. And then there's compulsory consultation. And this came out of a meeting I actually chaired many years ago with a lot of institutional investors saying there needs to be more consequences for the vote. It can't just be an arbitrary thing. So we came to this compromise, if you like, that there are serious compromises and you have to consult and you have to do something, or you have to tell investors what's been done. So that's the thing at the moment. There are no specific implications that you have to stand down for the board, although if a chairman of Remco is persistently approving policies that are real anathemas to investors, then obviously when they pop up for re-election every 3 years, they can vote them down for that reason. So we still do have that normal provision. Just again to point out, and maybe the lawyers on the call can be more specific, maybe in Ntokozo, but you are required to formally vote on your audit committee. That's why we call that's a statutory committee. But in my understanding, that's the only statutory committee or subcommittee of the board. The board is obviously voted by shareholders, and you have to vote each by individual resolution, the members and the chair of the audit committee. You don't have that for the REM committee. So there have been a couple of, so if we separate out that, we cannot have an ordinary resolution on the implementation report, and things to do. Every stakeholder and company needs to let the drafters know that doesn't work. For all the reasons, I don't think we need to belabor it. Then in terms of what are the consequences for the NEDs, and I do see the frustration of stakeholders and the impotence in a sense of exercising a vote, but not really seeing the consequences going through. So I understand why stakeholders want to see consequences. But if we make those consequences too draconian and too disproportionate, then why do I want to sit on a Remco? We're not going to have our best directors sitting on the Remco, because it's going to be the hazard committee. It's already a bit of a moral hazard committee, and no one's jumping up and down to serve as a chair of a Remco. Then we might get the B team. I'm sorry to say that. And there's a B team in two things. A, you've got to have quite a lot of courage, stand your groundness to negotiate against the CEOs and the executives of the company. They're there to negotiate and be hard-nosed guys and girls. So you expect them to be hard negotiators. If you have someone that's too compliant and too friendly as a chair of that committee, you're not going to get the dynamic tension. Nor do you want someone that's actually toxic and abrasive and can't meet compromises. So you need a sort of personality who is tough enough to stand ground and not be rolled over, but also high enough EQ that they don't break relationships when doing that. Plus, as we've seen from these discussions, there's a lot of technical stuff out there. You need actuarial grade stuff to understand what an on-target LTI is. You need legal nous to know employment law like Talita, tax stuff, Section 8C and its various interpretations. Kelly's got years and years of experience. Company law, Ntokozo, exactly what does this vote mean or not mean, and what are the consequences. So there's a huge amount of stuff that people need to know technically, and you need that EQ. So if those people are not available to serve on these boards, there's other stuff they can do. I know people think board NEDs are well paid, but given the risk and given what other stuff they can do in their own private investment companies, globally, locally, or executive pay, it's actually not a particularly well paid job, given the program that you get and the risk that you have. So I think those things need to be done separately. Non-starter, binding vote on the policy, interesting debate on the consequences and the things that I've seen. I think that the one strikes bill is too far. The ameliorated proposals would be a two strikes bill. So in other words, only when you get 2 votes against that implementation report do you have to stand down for re-election. Not great, but a little bit better than where we are. There's been some discussion about maybe the RemCo chair has to step down, but again, it's a corporate decision. You know, the RemCo chair doesn't have the ultimate vote. They could even dissent on some of the policies. Now they've got to take the hit, and they're probably the most knowledgeable, most courageous person. So again, singling out the chair that's been suggested. Maybe the Remuneration Committee becoming a statutory committee like the Audit Committee, then at least you don't get kicked out of the board, but you have to get voted onto the RemCo. Maybe, I don't know. Or we go with the current mechanism where you have to consult, you have to listen to what investors have to say, and if you really recalcitrant over time, that you'll get voted out when your 3-year term comes up. Otherwise, I think it's a bit disproportionate. Misty, I don't know what remedies any of the other folks have on the call to deal with that.
Well, maybe before remedies, Martin, exactly what you've just raised has kind of come up in the question box, and this question around engagement with shareholders. Should you have a negative vote initially? What is the plan in terms of engaging with those shareholders after that, getting further input? What do you do when shareholders don't show up for that engagement? It's kind of remedy effectively against shareholders having a negative vote, but then not doing much about correcting the situation.
Yeah. So I'd advise everybody on the call, if they haven't done so already, read a great paper by the Institute of Directors. It's on their website, and I'm sure our folks that help put this webinar together can circulate it on shareholder engagement. It started its life called shareholder apathy, exactly because of that. Because shareholders weren't showing up. They were giving you a clap, in the old-fashioned terminology, and then they weren't showing up to assist in fixing things. So I think what this bill, in whatever form is passed, hopefully it gets dialed back from its most draconian aspects. It's giving a gun, a big one, to institutional investors. That has to be dealt with very responsibly, and some of the really enlightened ones that I have the pleasure of dealing with quite often have actually said, we've stepped up. We really take this stewardship seriously. Other shareholders are going to step up, because if they don't, it's really going to break things. And I think message to companies on reading that paper on shareholder engagement as well. This now becomes a very important thing of engaging proactively with your shareholders on everything that you plan to do, and particularly when you're going to change things. So this relationship needs to informally get better. And I also think codes of conduct will need to be, codes of good practice will need to be instituted, that if a company votes against a policy, that it must, I mean, I don't think you're going to be able to legislate that, although maybe the JSE, in terms of its issuer regulations, and might be able to help with that, or even the Companies Act might help with that. You've got to give your reason for dissent. Even that is problematic, Misty. You know, you can have you can know what everybody wants, but what if there's some diametrically opposed views? You know, there are some very activist shareholders which have some very specific views, valid in their own context, but then you have others who are brutally commercial and are only worried about outperforming the SWICs, and they don't care really what the governance is like. So now you've got one lot that wants to say, unless 100% of these awards are based on headline earnings per share, I'm not voting for it. Then you have other investors who are very affair with ESG matters, and they say, no, I only want 30 to 40%, and I want to see empowerment, I want to see greenhouse gas emissions, I want to see water usage, I want to see gender diversity, all of these things, sustainability. Yeah, valid point of view, both actually. But now you can't please all the people all the time, which getting to some of the real governance issues, almost meta-legal governance issues, the whole structure of the board system, where shareholders vote a smaller committee to actually govern, the business. And then you have another committee who actually operates with these various disintermediation steps. Shareholder overreach, with all due respect to worthy and activist shareholders, if you have thousands of shareholders trying to govern and even operate a company, that aspect of shareholder overreach, I think, is very problematic. And I think in Ntokozo, we mentioned some other aspects where this whole concept of shareholders getting, too involved with the granularity, and when there's these other views, how do you deal with that? That's Misty. I think that's going to be a great challenge.
I agree. And in Ntokozo, it would be great if you could jump in here. I mean, it's worth taking a step back, I would think, just for everyone that's on the webinar, and explaining why it is we have this distinction at a very basic level between boards and shareholders and the committees that are involved. It would be great if you could run us through that, and then we could talk more about this overreach, which is certainly a concern.
Sure, Misty. I mean, there's a reason why the business and affairs of a company are and should be managed by the directors. They have a fiduciary duty whenever they're exercising all the powers that they have and in performing the acts that they have, that they are enabled to perform in respect of the company. It's quite key in making sure that companies continue to be well managed and for a proper purpose. And when you appoint a board of directors, you appoint a team of people who you trust to be able to do the job and do it right. And an example of some key fiduciary duties is acting in the best interest of the company and avoiding conflicts of interest. And no similar duty exists in respect of shareholders. There's no overarching standard against which shareholders must act in relation to the company. So there's nothing that binds them in the exercise of their powers and rights as shareholders to do so for the greater good. So placing the approval of such key documents within the purview of shareholders is a significant shift in power, and it assumes that shareholders will do the right thing to meet the intended effect of these changes. You're relying on the shareholders to do the right thing, and trusting that they will have the same intent and purpose as what is intended with these broader policies, which is not always a given. It's not that they're going to be aligned to the broader principles and the greater good, so to say. And on the flip side, you could also have an instance where shareholders become wary of voting against implementation reports because of the disruptive effect on the operations of the company. So if they like how the company is performing, yes, they may have some issues here and there, but they just elect not to get too involved because of the consequences of voting something as critical as the implementation report down.
Thanks. And on the consequences, I mean, maybe now is a good time to raise some of the more detailed questions that have come through. And panel, you may or may not have the answers to these specific questions. We can put a pin in it. But some of the things coming through are on the more practical side. So, for example, when are these individuals actually required to stand down? Would it be immediately after the vote has failed, or is it only at the next AGM? Martin, not sure if you've got some thoughts on that.
Yeah, it's not clear from the wording. I mean, I would think if you think about the routine every 3 years standing down, you stand down just before the AGM and then get revoted. And also, if the directors are expected to explain what they were thinking to shareholders, if they've immediately resigned after that AGM, I think that will be impractical. So it's abundantly not clear from the legislation. And I think that needs to be tightened up if this does see the light of day. I don't know what my legal colleagues think.
I agree, Martin. It's not clear from
may actually result in.
Sorry, go ahead.
Sorry, Kelly, do you want to go ahead?
Pick up with.
Sorry, there's a bit of a time lag here. I was going to say, Martin, I agree. From the drafting, it's unclear, and I think one of the concerns that we have is if it was immediate, as Ntokozo highlighted, there's a risk that it's not going to only affect the RemCo. It could affect a number of committees. You could have to immediately resign from the board, and we could then be in a position where we have no one with sort of REM experience and no one to address the concerns. So hopefully, it's as you said, it's actually meant to be before the next AGM, but the drafting is unclear, and that obviously leads to a lot of interpretational issues with other provisions.
And I think, Misty, practically a lot of companies may actually propose some conditional resolutions as a manner of dealing with this, where, you know, if the relevant policies are not approved, then as a condition to that, we propose the re-election of XYZ directors who you know would be affected as a potential way of dealing with this.
Yeah, that's a great idea. And obviously some of the things we've been talking about internally as a firm, how to work around these provisions should they come into effect in their current form. And Ntokozo, while we're with you, and I guess also a more technical point, what are the consequences of not complying with this provision of the Act should it come into force in its current form? Where are people at risk in terms of the Companies Act specifically?
Sure. So, I mean, the general compliance provisions under the Companies Act would apply. So you've got your, Section 218 liability for potential loss or damage suffered by a person as a result of contravention of the provisions of the Act. The company could face potential court action or be subject to complaints procedure under the Companies Act. They could have compliance notices issued against them, which then, if they don't comply, then puts them at risk for potentially having an administrative fine levied against them. And there's also the practical issue where, as you're filing your annual return, there's a compliance checklist that you have to tick off, which largely indicates that you've complied with the relevant provisions of the Companies Act. Would they be in a position to tick off that they have complied with this, knowing that you haven't? And what does that then mean for your filing of your annual return?
Yes, and which I presume, should you not be able to answer that in the affirmative, you're then obviously not able to file your annual return, leading to deregistration. So maybe the kind of topic we could get into as a panel now, and I'll circle back on some more questions, is what are some of the ways in which this could be better? I know, Martin, we've discussed some drafting errors. We spoke about potentially, and you'd raised it earlier, making the REM committee more like the audit committee. Maybe I'll start with you, Martin. I mean, what are your thoughts in terms of how it could be drafted better than it currently is, but achieving effectively the same outcome?
Yeah, so I think so there are a few just obvious glitches. I mean, for example, the preamble statement says, naughty REMCO members, I can phrase it like that, are ineligible for election. I mean, I don't know what that means. Are they then can they never be elected? That just doesn't accord with the actual insertion into the legislation, which says, as was said correctly, they stand down for re-election. So that also needs to be tightened up in terms of that. Then I think the UK style remuneration policy binding vote is probably tenable. It's going to make life even tougher for business. Of course, everything else makes business quite tough in South Africa, but I think we'll deal with it as a profession and as corporate business. We will have to really raise our game in terms of consulting with shareholders. I think outside of the legislation, there needs to be a code of good practice that's built. I don't think there's so many details of this that you can't actually legislate. So, for example, Ntokozo mentioned materiality. It says material changes. So the UK legislation actually spells out a lot of detail. So what can you pay on termination of employment as a maximum? What can you pay on a sign-on bonus? It must be limited to what's being left behind at the other employer. And you've got to have an independent expert sign off on what that value is, and increases can be no more than X or no more than Y, and the compa ratio can be no more than 120%. All of those details would need to be specified. And I'm not saying those are necessarily the right ones. I'm just saying we have to work out what is a framework. Because if you say a binding policy, there's got to be some discretion. Where is that permissible? Where is that allowed? Is it discretion of up to 10%? Is it up to 50%? So all of these things need to be done. So I think that's going to be very, very useful that, and I see a bit of a codesa of institutional investors and companies getting together and saying, okay, you've got a gun. Let's say this stuff passes in its current form, but it's not in your interests to shoot us. When it's not merited, you're going to literally shoot the goose that's laying the golden egg, maybe. So, and that's not in the interest of shareholders. They actually do want to manage these funds for the pensioners and the investors, and many of them have got enlightened interests in sustainability and common good and those sorts of things. So I think it's got to be used very judiciously. I think there needs to be a code of conduct, and a bit like playing bridge as well. I know one big institutional investor doesn't vote against a policy first time around. It abstains and tells the company no in certain terms why it's doing it. So it's a bit like a bridge hand. When you bid for no Trump, doesn't mean you really want to play a for no Trump hand. I can never remember what the convention is, but you're telling your partner something. So it's a bit like if the company's act is too draconian, then investors have got to use it very judiciously. And I think getting shareholders and investors shareholders and companies together in a bit of a REM governance codesa would be brilliant, and I think that would be helpful, even if the act has got some very dangerous bits. I think clarity has got to be given around exactly what the definition of minimum, maximum, and the bottom 5% and the top 5% pay to deal with the intended consequence, which I'm not unsupportive of. We do have to deal with these issues, those societal problems all around the world, but do so sensibly. And I would strongly advise, and I think many of the stakeholders we've been dealing with, as Talita says, there's this EEA4 form that the government of the day needs to, and the various departments need to get together so it's absolutely consistent and sensible. That what you report in EEA4 form is what you report in your remuneration report. And there's already some quite helpful, we actually had some great interaction with the folks who look after the EE reporting and the reporting to the EE Commission. And they were delighted to engage with remuneration professionals to understand all these different ways of reporting remuneration and what the intentions are and things like that. And they actually drafted a sort of a guidance note on using on-target pay for that differential already. So quite progressive thinking and very welcoming and constructive dialogue between business professionals and them. So I think get that right. It can be done outside of the legislation. You can do a clever legislative pass the ball thing of saying that these pay elements must be disclosed in line with the EE legislation section XYZ, whatever that might be. So then that allows a bit of a sub-process, a sub-routine to continue to deal with these technical issues. I think that would be great. So I think those are the main things. You can't do the binding vote and implementation report. Sympathetic to the consequences, but we've got to do it in a way which doesn't make it untenable to sit on boards, and just throwing hand grenades at board members is not going to solve this very complex problem throughout the world. And the last thing I think I need to say is, if we pass this act in its current form, our remuneration governance will be by far the most onerous in the world. Left-right combination of UK binding vote, which is very uncommon, by the way. All of North America, many other countries are in our stage. There's say on pay, but nothing binding. So that's very stringent governance. And then the right hook is we have the two-strike version of the Australian thing, but it's one strike. So it would be very onerous. And just take it 2 steps back. Business has a huge amount to do in this country. Business has got to create inclusive growth, job-creating inclusive growth, and deal with all the horrible legacies we have, seize all the wonderful opportunities that I think we still have in this country, and overflow decent economic worth into every hardworking, credible person in this country, and get our kids into that, whether I'm a poor family in rural Mpumalanga or an affluent person in Cape Town or Gauteng. Our kids of this generation have got to have that opportunity to get this REM, even this excessive absorbent REM, according to so many stakeholders at the top. If every kid in this country, there's a path to get there, then I think that makes this less about class warfare and those sorts of things, and more about how do we get this right? What is the right thing to do? That business thrives, creates jobs, and pays everybody, and it's a fair wage for what they do. And I know I'm sounding dewy-eyed and Bambi-like in this, but I think this is a global aspiration, and it's profound. This is very intense in South Africa because we have such an issue with inequality. But every country in the world, there's the UK High Pay Center, there's all sorts of stuff going on in the US of people. Thomas Piketty, who's a rock star econometrician, who's dealing about the inequalities of employment versus wealth, all of these things. Not easy. I will stop waxing lyrical there.
Martin, maybe to get us back into the question, and some are specific, and maybe both for you and Talita. The first is whether and how private companies' EEA4 form is open to the public. Is that accessible to the public at the moment, Talita?
No, it's not a public document. So the only way to get that is through a PIA request.
And who would be able to make that PIA request? Is it a fairly straightforward process or quite complex?
Well, it is someone that has a right or needs that information to exercise or defend a right. So it's not for every Tom, Dick and Harry, that can just come along and say, I want to know, what's in your EEA4 form.
Okay. Good. Hopefully that answers that question. Another question, we're going to bounce around a bit here. I'm conscious of time, and there are a few questions kind of scattered across a number of the categories we've already discussed. Mark, maybe more aimed at you, but happy for anyone to jump in. Where we've got a multinational group and we have directors or employees who are remunerated at both SA Holdings level and at the foreign company holding level, would we be taking both of these into account when we actually disclose income? Do you think we'll need to be disclosing both sources of income?
I think we will. Otherwise, there's just too much opportunity for gaming what comes out of local companies and offshore companies. And I think we've just got to do it consistent with the current Companies Act listing requirements. So if you're the CEO of a multinational which is listed in South Africa and maybe gets pay from offshore and local jurisdictions, I think you've got to show the aggregate pay.
Thanks. One of the other questions that's come out, and it's come through various forms, is when is it coming into effect? People seem, and I'm sure people on this call are feeling somewhat panicked. Panicked that they have their AGM coming up, they're not ready, what do they need to do? Just from my perspective, and I'm sure Ntokozo might want to add to this. At the moment, there's no proposed timeline, and jump in anyone, timeline for the implementation of the changes. The last amendment, I think, took around 5 months to come into effect, and that was on an expedited process, but it really completely depends. They might get their act together and be very quick. Our current expectation is that we're likely to see this come into effect early next year, but that is completely subject to change, and we really just don't have an indication at this stage. So you don't need to be ready for next month, I don't think. That's organized. No one's that organized.
And
I think also if I can add,
yeah, go ahead.
The minister has indicated that the intention is that the changes will be implemented shortly after the second round of public comments, and the comment period is about 30 days. So yeah.
Yeah, but they will put a timing into it. So it'll probably be, companies with year ends ending in some calendar year, either the 22, I think the 22 financial year is probably the horse's bolted unless they make it, after September. But they've got to give time now, and the UK experience really shows that. And by the way, note to ourselves and to everybody on the call, we're going to have to phone our friends in the UK big time to really get our acts together in terms of how to do that. And I've already chatted with my friends and mentors who taught me a lot of what I know about REM in the UK, and they have said, don't worry, this can be done. But they also agree that the implementation report can't be done. So, but I think on the policy, we'll be able to phone a friend on that.
And then maybe one of the other questions that's coming through, and it links to what we spoke about way in the beginning, to whom do these proposed amendments actually apply? Some concern coming through about whether you think private companies are eventually going to need to comply with this. I mean, Martin, I'm not sure if in your networks that's something that's come up as something possible down the line.
So as I read it, the Section 30 amendments, which are, that you've got to do a REM report and you've got to name your directors and prescribed officers, I think that applies to private companies that have to be audited. I think it's clear that Section 30A, which is everything we've been talking about in terms of, I think, the pay gap disclosures and the binding votes, that's listed companies and SOCs. And then I think we haven't really been talking about this, but the access to information that I think, Ntokozo, you mentioned it, that anyone can really approach the company for access to all of these documents, the financial statements, and which will now include REM reports with details of what everybody's paid. So that kind of left-right combination of name disclosure and more access to the information, I think that already in this current bill means a lot of confidential information will be put into the public domain. In terms of the actual voting on private companies, I don't see that happening anytime soon. The real views of excessive pay, I suppose, are in the listed company space. But, there's massive pay and massive companies in unlisted spaces as well, which, nobody really knows what... well, those of us who advise on the REM do, but there's no ways that the public generally knows what's going on in that space, and government may wish to know about that as well.
And then maybe the burning question on everyone's minds is, what do they need to do next? And I think following the discussion we've had today, certainly from our perspective, we're calling for strong lobbying against some of these provisions coming in their current form, and some clarity around certain of the language. Anything else people need to be doing in terms of immediate next steps? For those who aren't aware, but I'm sure everybody's been following this, submissions, or rather the window for public comment closes tomorrow, I think. So if you haven't made any submissions, and you'd like to make submissions and you don't know how to or where to, you're welcome to get in touch with us. We will be making submissions, obviously on behalf of Bowman's, but also inputting a number of client comments and client concerns. So you're welcome to reach out to us, and Kathy Truter on our side is the right person to connect with. I'm sure our team can share her details after this. Anything else, Martin, Ntokozo, Talita, Kelly, that people need to be thinking about right now? Do they need to be drafting their new REM policy in the background and worrying about putting in place some codes?
Okay, let me maybe start off here. So I think intensive lobbying against the really impractical bits. Phone your friendly investors. Get even better in touch with your shareholders, and also phone your friends in the UK in the REM space to see what you need to do, and obviously your advisors will be a good point of advising how to deal with the probable implementation of the policy report, vote on the policy report. Other colleagues?
Anyone have anything else they want to add? Anything else you've thought about that perhaps have come out of the questions? Or if you do have a question, you're welcome to put it on the Q&A now. we've got a bit of time left.
Misty, I think some of the other things, there's some quite courageous and forward-thinking things which are already being done. You know, a certain big retailer, I think is represented on the call, has made some quite proactive steps about publishing remuneration of junior people. And you know, contrary to many of the stakeholder views, I think that boards of companies don't sit in their dark corners seeing how best to exploit workers and gratuitously overpay their executives. There's very genuine and very impassioned thinking and wrestling with these issues, and really I think it's quite important that we rebuild some trust. I think I mentioned it before, between the big stakeholders, you know, organized labor, disorganized labor, who the ordinary employees, government and business, you know, as we call the social partners, the NGOs, that we find some consensus views, and it really needs good leadership. You know, from the politicians of the day, the business leaders, the boosters, the Nedlanks, the BLSA, all of the credible leaders around here. And I think there are some things that people violently agree on. I think we all need to do business better. We need to enable business to do better. And I think this legislation is a bit of an example of misalignment between government strategies and objectives. You know, in one sense, we've got some great enabling initiatives and job creation aspirations and things like that, getting rid of some red tape. And then we've got this act, which definitely comes across as being quite hostile to business. I mean, the wording of the preamble is a bit of a shot across business spars, and the language is very emotive and emotional, and doesn't come with the necessary balance that I think, you know, really responsible addressing these problems. And I think as well, you know, one of my dear colleagues who sits on this remuneration subcommittee said when we first discussing this, you know, Martin, I think we're being tone deaf. We need to listen. We need to hear what stakeholders with valid concerns have. So on one hand, we do hear business leaders and REMCO members bemoaning the constraints that one's under in terms of executive REM. But, you know, we've got to be sensitive to the aspirations and the needs and the thoughts of many other stakeholder groups. So I think getting together, talking about sharing some of these inconvenient facts. You know, an executive running a South African company gets paid about a third in whatever currency you want to convert into of somebody running the same company, same size, same complexity in the developed world. And in the US, sometimes more, sometimes 4 times. So if we now slash pay to half, we exacerbate that. And people stay in this country because you know, those of us who live here love the place, and we have amazing challenges and amazing potential for impact that you might have in a larger economy. But if you tip the balance too much, I mean, I read an article by an activist shareholder that said, you know, you're not going to keep executives in South Africa by paying them more. No, you're correct. They're not moving because of money. They're already very well off because of money. The fact that they might get 2 times more in the developed world, but they'll pay, the cost of living is 2 times more. So that's reasonably rational. It's more about coming up with a workable way of doing things and redirecting some of this energy to the right things, the sort of things that Talita mentioned, you know, systemic issues of getting poor people's kids the same sort of opportunities that you and my kids have had, you know, wonderful opportunities of great education, great exposure to business, those sorts of things. So I think it's a bit of a rallying call. It's a symptom of greater ills and greater dysfunctionality in our society. But we cannot break the system just because of 50 people's pay that many people find objectionable. Because if we don't have that ability to pay our executives a market rate, even if that market rate is objectionable to many people, we're not going to function as a competitive business environment. You know, that's what I see from my point of view. As with everything in remuneration, it's compromise between 3 or 4 forces, which are, never mind Newton equal and opposite forces. We've got somebody like Tesla who's got a zillion forces in a zillion directions we've got to deal with.
Maybe before we close out, there are a couple of additional questions that have come through. The one that maybe we haven't touched on, which is a very important point, is whilst setting out the pay gaps is one thing and the redress mechanism another, there is potentially quite extensive costs involved in this exercise for employers. Am I right, Martin? I mean, is that something you've engaged on and given thought to?
It's not terribly onerous to do. It needs to be done, and I suspect your various service providers and payrolls, providers, SAP, PeopleSoft, and Workday, and that they just need to put provisions in there, because you can parameterize all of these things quite clearly. So I suspect really it's something that the payroll management systems, you need to be able to push a report and have your remuneration reporting requirements come out and your EEA for things come out. If you do it handmade with a spreadsheet, it's going to be messy.
And then a couple of other things, whether we're expecting the period for public comment to be extended. At this stage, I don't believe so, but we'll know certainly today or tomorrow if that's the case. The other point is, I think there's a question about whether it's being recorded, the session. It very much is being recorded, and it's going to be available later today on our website. So you'll be able to watch it again or share that link or however you might like to use that. I think that concludes the questions that we're able to answer on the call. Before I wrap up, anything from anyone else? I think it's been a very useful session. So thank you to the panelists and for all the questions. We've had a very high number of people join today's webinar, which is great and shows a keen interest on the topic. So we're glad that everyone's getting engaged, because it's certainly time to do that on these amendments. Anything from anyone else? Any closing comments? No. Thanks, everyone. And you get an extra 12 minutes in your day, so that's a positive. And thank you for joining.
Thanks, Misty. Thanks, colleagues.
Bye, everyone.
Bye.